Thanks for joining in our continuing series of virtual talks and discussions at a time of pandemic. And today we have Professor Rosalind Dixon and Professor Twomey, who makes a welcome return, and Professor Dixon makes a welcome first appearance. And the topic is state border closures and the challenges of Section 92 in the High Court. And I'll introduce our speakers briefly. We'll start off with Professor Rosalind Dixon, who is Professor of Law at the University of New South Wales and Director of the Gilbert and Tobin Centre of Public Law. And she'll talk for about 5 minutes and then be followed by Professor Twomey, who's Professor of Constitutional Law at the University of Sydney, who will talk. And then Rosalind will reply, and then we'll go to questions and discussion. So we'll lead up with Professor Dixon and then Professor Twomey, and thanks to those of you who've sent in questions, which we'll get to when we get to the question and discussion period.
Obviously, we all miss the opportunity to get together in person, but it's wonderful to have these sorts of fora where we can connect virtually. So the state border closure issue has attracted a lot of press and a lot of debate, and I have enjoyed being one of many participants in that debate as a matter of public policy. But the closures also raise an issue of constitutional law, which is of significance and likely to be decided by the court in light of recent developments. Anne's going to talk to you specifically about the challenge before the High Court and give her view, and I will then respond and give mine. But it's important for our broad audience just to introduce the issues at stake. Early on in the debate, Alexander Downer raised a question about Section 117 of the Constitution, but the more considered view is that the relevant provision that is engaged by these measures is Section 92 of the Constitution. Section 92 provides on the imposition of uniform duties of customs, trade, commerce and intercourse among the states, whether by means of internal carriage or ocean navigation, shall be absolutely free. There's an interesting history about the words of Section 92, and some last-minute changes to it were made aboard the Lucinda. But my job is not to give you that history, but rather to give you a sense of what the stakes are in the current debate about the interpretation of Section 92. We have relatively little guidance from the High Court on this provision, but we do have some relatively clear guidance. The first is that the word intercourse essentially means movement, therefore movement across state lines. That was established by Justice Dixon in the bank nationalisation case. It's been affirmed in a range of subsequent judgments, including as early as 1992 in the ACTV nationwide news cases. So intercourse among the states essentially means movement of persons across state lines. And then the question becomes, what do we mean by absolutely free? Like most legal phrases, it's not exactly what it sounds like. It's not tenable to have a position that says there can be no regulation of movement across state lines. If that were the position, you would have a right to traffic in narcotics or firearms across state lines. So in absolutely free being the term, it is a term of art which has to be interpreted as allowing at least some reasonable restrictions. No lawyers dispute that or suggest otherwise. You might think of the terms in the US Constitution of the First Amendment that say Congress shall make no law abridging the freedom of speech. It's always been understood that those words, even though they sound absolute, do not prevent Congress from imposing some sensible regulation, such as a regulation preventing people shouting fire in a crowded theatre. That's the famous example in the US, and you could imagine an equivalent here in terms of firearms or narcotics. So absolutely free doesn't mean no prohibition. So what are the range of positions that are plausible and on the table? One historically favoured position was that Section 92 effectively created an individual right to sell goods across state lines and to move across state lines for commercial purposes. That view was long favoured for much of the 20th century, but in an important decision of the Mason Court in Cole and Whitfield, the court moved away from that position and said that the High Court had essentially created confusion and misread Section 92, and that the better view of Section 92 is that it's a federalism guarantee. It's a guarantee of a nationwide market and free movement only insofar as it serves a goal of a unified or common national market. That position has now been affirmed multiple times by the High Court and is really seen as settled law. The question is how that affects the freedom of persons to move rather than goods and services. That is the area where there is less guidance from the court. It seems to me that there are effectively two broad ways of understanding the guarantee of freedom of movement in terms of a structural guarantee of common markets and federalism. One is to say that it's a very broad guarantee subject only to reasonable limitations or measures that are reasonably necessary to advance a legitimate purpose. And the other is a slightly more limited guarantee that says that it protects only against discriminatory burdens against movement between states. That issue will be ventilated, no doubt, before the High Court. My own view is that it probably is sensible to prefer the somewhat broader view, which says that the Section 92 guarantee protects movement across state lines, subject only to the right of states to impose reasonably necessary regulations or limitations on that movement. Not because it's an individual right, but because it's a structural guarantee of the freedom of movement necessary for a true unified national market and federal system. 5 judges in a case called Commonwealth and the Commonwealth in 1994 affirmed that approach. 3 judges, Chief Justice Gleeson, McHugh and Gummo, seemed to support that approach in a case called AMS, v AIF in 1999. And there is a degree of support for that view in the more modern cases, the betting cases, Betfair 1 and 2, even in relation to trade and commerce. So to summarise, my view of Section 92, and I think Anne would probably agree, is that it is a structural guarantee that is relatively broad but not unlimited and subject to reasonable restriction. The test for what is reasonable will no doubt attract quite a lot of attention from the High Court. As some of you may be aware, the High Court has been spending quite a lot of pages and time recently debating whether to embrace a proportionality test, which is common in Europe, Canada, South Africa, Hong Kong and a range of other countries, or to stick to a more tried and true Australian formulation of reasonably appropriate and adapted as the test for validity in this context. There are lots of interesting debates we could have from a legal point of view about that, but in essence the test will be one of reasonable necessity. If laws burden freedom of movement across state lines, are they reasonably necessary to achieve a legitimate state purpose? And that's the really interesting question that the High Court will no doubt have to grapple with. Anne's going to talk to you a bit about those proceedings, and then I'll explain my view about the specific challenges for the court and all of us in resolving that question of reasonable necessity.
Thank you very much, Ros, and thank you very much, Jared and the Sydney Institute for inviting us both here today to talk about this. So my role here is to have a bit of a talk about the cases that the High Court was going to hear. Initially there were 3 cases that were initiated before the High Court. The first case brought by Clive Palmer, which was against the Western Australian restrictions. The second case was brought by his company, Mineralogy, and also joined a lawyer who worked for that company, which was taken against the Queensland border restrictions. Now in that case, the particular lawyer had been living in Queensland, moved his principal residence to Perth, but had his de facto partner in Queensland, and then because his principal place of residence was in Western Australia, couldn't go back and travel to visit his partner in Queensland. So the complaint was that non-Queensland resident employees could not travel to Brisbane from Mineralogy's office in Perth for the purposes of business or for personal reasons. And that is because they didn't fall within the particular exemptions that had been established in the Western Australian legislation. Now the third challenge was brought by a group of bodies completely separate to Palmer and his company. They were initially encouraged by Pauline Hanson, although she wasn't a party to the proceedings because she wouldn't have had standing. And the lead plaintiff in that case was a travel agency called Travel Essence, but it involved a number of people who were again complaining about the Queensland border crossing, in this case trying to get from New South Wales into Queensland. Now, both the mineralogy and the travel essence proceedings have now been discontinued in the High Court, so they're not proceeding, and that is because the Queensland border has now been opened, at least in relation to the relevant plaintiffs in those proceedings. As we now know, there are also now restrictions in relation to Victorians heading into Queensland, and we'll come back to that later. But the only case that's now on foot is the Clive Palmer case. So that's the case that I will talk about today. The other thing that we need to know here is that it's not going ahead immediately in the High Court. There was an inability to agree on the relevant facts that were needed in order for the High Court to determine the law. So that's been referred to the Federal Court. The hearing for that was supposed to have happened before today's proceedings. The idea was we were going to reflect on what had happened in those proceedings, but they were delayed because the primary witness, the primary medical scientific witness, was called upon to go to Victoria to help deal with the coronavirus outbreak there, and wasn't able to participate in the proceedings. So the proceedings were delayed. They'll now occur next week, so that's the 27th, 28th and 30th of July. It is hoped by the parties that there will be a quick judgment within about a fortnight, fingers crossed, and then it would be able to go back to the High Court, probably in the October sittings in the High Court. So that again assumes that the Western Australian border would still be closed to Queenslanders by that stage. So what is the nature of the Palmer case? Well, Clive Palmer claims that he wishes to travel from Queensland to Western Australia by his private aircraft for the purposes of being engaged in the management of his business, which has an office in Perth and which does mining activity in Western Australia. Now, he's prohibited from doing so because he doesn't fall within the category of an exempt traveller under the Western Australian law, and his application to enter was refused on the 20th of May. He also says that he has staff who work on a fly-in, fly-out basis between Brisbane and his Perth offices for work, and that they're currently unable to do so. And I should add that his company Mineralogy is also a party to this proceeding. Now, Palmer is relying on the two separate limbs of Section 92 of the Constitution. So there's the trade and commerce aspect, and then there's the intercourse aspect. And Ros rightly focused on the intercourse aspect, but curiously, Palmer is also relying on the trade and commerce aspect, so we need to address that too. Now, the High Court, in that case of Cole and Whitfield that Ros referred to, had said that you only breach Section 92 in relation to trade and commerce if your law discriminates against interstate trade and commerce for a protectionist purpose. So that's the test that you need to meet in order to satisfy that trade and commerce limb. Clive Palmer says that he needs to be physically in Perth in order to supervise litigation to which his company is a party. Apparently, Clive is a man of a great deal of litigation, including this one. And his exclusion from Perth, he says, in his pleadings, benefits in a protectionist manner the opponents to his litigation, which I find a quite surprising claim. He also claims that he's wasting expenditure on rent of his Perth offices if he and his staff are not able to fully utilise them. And he said that that's a disadvantage that's not imposed upon his competitors who are based in Perth, and that this amounts to discrimination against Clive Palmer and his company, and that it is discrimination that is protectionist. Now, Western Australia responded by saying, well, Clive Palmer can pursue his business interests and supervise his litigation by using this thing called technology. So the telephone, email, teleconferencing, video conferencing, internet-based conferencing, etc. Western Australia also pointed out that at the moment litigation is being run by teleconferencing and the like, and therefore, like everybody else, Mr. Palmer would have to cope with those changes. Palmer, however, replied that due to computer hacking attacks, many of his mineralogy's company's critical documents are on a server that's based in Western Australia, and that deliberately does not have links that allows the communication of that material outside of Western Australia in order to secure it from hacking. So there is a bit of a dispute going on about the practicality of his ability to deal with this from a distance. Clive Palmer also says that his personal presence is required in order to properly fulfil his supervision duties in Western Australia. Now, these arguments based on the Trade and Commerce limb are, I think, problematic because it has been interpreted, as I said, as prohibiting discrimination against interstate trade and commerce in a protectionist manner. Not discrimination that just simply might give you some disadvantage in litigation, or that might mean that you're not actually, fully using your office space. Okay, you've actually got to show discrimination against interstate trade and commerce for a protectionist purpose. And I think on the basis of those arguments, it would be quite difficult for Mr. Palmer to achieve that. And probably for that reason, Mr. Palmer's pleadings have added a broader claim. And this is that the border closures deny businesses outside Western Australia which are engaged in the provision of personal services the ability to enter Western Australia to provide those services, and that this then protects Western Australian competitors from that interstate competition. Okay, and that's establishing a much more plausible argument in relation to discrimination against interstate trade and commerce for protectionist purposes. Slight problem is that Mr. Palmer himself doesn't seem to fall into that category, but he is potentially able to establish that the law itself is flawed in that particular way. Now, Western Australia, in its response, noted that its laws do have a number of exemptions. So, for example, in relation to certain fly-in, fly-out workers, workers that need to be physically present in relation to agriculture, food production, primary industry, etc. So it's trying to show that it actually has been reasonable in the way that it's done this in order to prevent any kind of protectionist types of allegations. So that's a further factor that's thrown in here. But one could say that the border closure is still likely to have at least the effect of some lessening of competition from outside Western Australia, even if that is not the purpose of the law. Now, Western Australia also noted in its pleadings that the economic effect of COVID-19 on it for the first 2 quarters of 2020 will be to reduce Western Australia's gross state product by 5.1% and significantly increase the underemployment and unemployment rates within the state. So partly what it's saying there is that its own laws are actually disadvantaging itself. And that's inevitably true. That's going to be the case in relation to all states as well. The fact that some of the community isolation measures have now been eased, reducing the economic impact of this pandemic, only occurred because there has been no community transmission of COVID-19 within Western Australia, and reintroducing those measures due to an outbreak, if it were to occur, of COVID-19 within the state, would have an adverse effect on the Western Australians' economy again, including unemployment, gross state product, etc. Now, all this shows that although the reason for closing the state borders might well be health, health is actually intimately connected with the economy. And that potentially has an impact in relation to these Section 92 arguments. So by protecting health, you've damaged the economy, but equally by shutting the borders and protecting the health, you can actually improve the economy within the state, so long as you don't have any further outbreaks. So while there is a clear health purpose for the imposition of the border restrictions, there also is an associated economic purpose. Whether or not that can actually be regarded as a protectionist purpose, however, remains to be seen. If it was able to be established that the border closures discriminated against interstate trade and commerce for a protectionist purpose, even then that's not the end of it. The High Court has previously accepted that if the purpose is a legitimate one, such as protecting public health, then the law could still be valid if it is reasonably appropriate and adapted or reasonably necessary to achieve that legitimate purpose. And this is where the case is likely to be determined, on that question of whether or not the law is reasonably necessary. Now on the other limb, the intercourse limb that Palmer is relying on, there you've got a much clearer case of at least a prima facie type of breach. So does the law impede intercourse, that is stop the movement of people across state borders? Well, yes it does. All right, so no question, it's not as questionable as discrimination against interstate trade and commerce for a protectionist purpose. Here we absolutely have a law directed at specifically stopping people going across the state border. So that makes the law much more problematic. But again, the High Court has accepted that in some cases an impediment will be acceptable if the law is reasonably necessary to achieve a legitimate end, such as public health, and there are no other equally effective means available to achieve that purpose or object which impose a lesser burden on intercourse among the states. Now the state of Western Australia in its defence has pointed out, first of all, that persons may be infected with COVID-19 and spreading it without any symptoms at all being present, so you can't tell when they want to cross the border whether or not that's the case. Equally, that testing during that pre-symptomatic period is unreliable. So just saying, okay, well you can let anyone in so long as they pass a test that shows that they don't have COVID-19, that in itself is not necessarily going to work. And that the primary ways for preventing the spread of the pandemic include personal isolation of confirmed cases and their close contacts, and community isolation measures to stop the geographical spread both within the state and across state borders. Western Australia claims that no isolation measures, apart from the border closures, would be equally effective in reducing the risk of community transmission of COVID-19 in Western Australia, and that those measures cannot be eased without increasing the risk of morbidity or death in Western Australia unless community transmission in other states and territories has ended. So, here the case will turn on two things. First of all, the evidence that's presented about what is reasonably necessary, and secondly, whether there are less burdensome ways of doing it, but secondly, the timing of when you make that assessment, and that's going to be crucial. So, the big issues in terms of whether there's an equally effective way of containing the spread of COVID-19, that's what the federal court's going to be looking at in terms of facts. So would it be practical to do something else like localised lockdowns? So we've seen in Victoria, we had lockdowns of particular buildings, we had lockdowns based on postcodes, but we also have doubts about the effectiveness of that because it's quite clear the coronavirus has spread significantly throughout Victoria and is continuing to do so. So there's a real issue in terms of evidence as to how practical that is. One of the benefits of state borders are that you know where they are, and you know you've got clearly defined areas, and it's much easier to deal with there. Western Australia says that there are no other effective measures. Queensland, however, has now introduced restrictions based upon the exclusion of people who have visited declared COVID-19 hotspots within the last 14 days. And those hotspots are identified by local government areas. So New South Wales, Campbelltown and Liverpool are hotspot areas, so you can't go to Queensland from there if you've been there within 14 days. But all local government areas in Victoria are identified. So there's a question there as to whether you're doing it by state or whether you're doing it by local government area. It's a bit of a fudge because they've included every local area in Victoria, but it might be the fudge that actually stops you from breaching Section 92. The Northern Territory also is doing the same thing. If you have a look at their list, of COVID-19 hotspots, far more extensive in relation to Sydney. So where I am standing now is a COVID-19 hotspot according to the Northern Territory in the city of Sydney, and indeed all of the Sydney local government areas are included in the Northern Territory list. But I think this will be the vulnerability for Western Australia. If it can be shown to the court that there are other ways of doing it other than just simply shutting your border full stop, that is potentially where Western Australia might fail if it does. Final point I want to make here, because I'm running out of time, is the timing point. So there's a real issue here about the point of time at which you decide what is reasonably necessary. Is it the point of time at which the relevant law or order was made at the very beginning? Is it the point of time at which the proceedings commenced? Or is it the point of time at which the High Court hears the matter or is making its determination? Because frankly, the facts have changed enormously through all of those points. The point at which the state's borders were originally shut is quite different from the point at which the proceedings were actually commenced, when there was virtually no community transmission going around in any state. It had either been eliminated in all states or was being contained. And then we get to the point now where we see a massive increase in spread of the disease in Victoria, borders shut with New South Wales, but before that happened, getting through into New South Wales and spreading into New South Wales as well, showing the value of stopping borders and doing it at the appropriate time. So the timing issue is really going to be critical there. So conclusion in all of this, we know that an unconstrained outbreak across state borders can be very dangerous. We know that testing itself is not adequate to deal with that, to prevent it. The purpose of the border closures is clear. It's for the protection of health, but there is also an economic protection that's involved. Is it protectionist? Not really in the broader sense, but it's possible it could be regarded so, and at least in relation to some aspects. Is it for a legitimate purpose? Yes, clearly it is, in terms of protecting public health. Is there any other equally effective measures that could be used to achieve the purpose of preventing the spread of the disease? That is the ultimate question, and that is probably what the case will be decided upon, assuming that the borders aren't open before the High Court makes its decision. Thank you. I'll turn it back to Ros.
I just want to highlight three things that I think will be tricky for the court and potentially the federal court in making appropriate findings of fact. The first is about the issue of what the public health objective is. Is it suppression or elimination? The second is to talk about that sort of local government area approach and issues of proof. And the third is around time frame. So the first thing I think is interesting is that there is a very live debate in the broader community and certainly in the public health community about whether the objective should be what Nick Coatsworth and others are calling aggressive suppression or containment versus elimination. My own view is that elimination should be the aim, and that requires more stringent measures and greater restrictions. That debate will affect the degree to which measures are reasonably necessary in order to achieve the public health objective. Because if the public health objective is containment, one can allow for broader movement and fewer restrictions than if the objective is elimination in terms of community transmission. The High Court will no doubt have views on that, but the tradition of the court is to defer to expertise, the executive government and medical experts on that issue. So all I think is important to note is that clarity in relation to the legislative objective is critical, and that there has been a somewhat lack of clarity, certainly in some of the statements from government, as to whether their purpose is elimination or containment. And clarity is necessary for the court to defer and then measure the relevant questions of validity against that objective. If the objective is elimination, the court will be more deferential to measures under Section 92. If the objective is containment, more could be permitted without undermining that objective. The second issue is in relation to proof, and it again goes to a question of expertise. The Queensland measures and the Northern Territory measures are facially more likely to succeed against a challenge under Section 92 than the WA measures, as Anne suggests. But I do think one thing that will need to be ventilated and considered is issues of compliance and proof. There is a great deal of reliance at present on self-reporting. Have you been in a hotspot in the last 14 days? And we know from the early cases coming into New South Wales from Victoria that there was a degree of non-compliance by people in terms of self-reporting. The Northern Territory and Queensland measures do rely on honest self-reporting, because even if your driver's licence reports your address as, let's say, the City of Sydney, you may well have gone to Liverpool or some other hotspot within Sydney for an errand, a sporting event, to meet friends, and that would not be in any way traceable by government in the enforcement of its measures. And so I do think that compliance is a legitimate reason for thinking that the WA measures are indeed reasonably necessary if there is a credible amount of evidence to suggest that self-reporting of having been in a particular area is not sufficient to prevent cases coming across the border. And I think that the questions of evidence will be very significant in that regard, but the period in early July where there was an effort to limit containment, efforts to focusing on travel from hotspots in Victoria into New South Wales, manifestly did not succeed in preventing COVID-19 positive cases from coming into New South Wales in a way that, if appropriate evidence is led in the federal court, I would suggest favours upholding the WA law against Mr Parnas' challenge. The last thing I want to say is about time frame. I really share Anne's concern that the question of timing is critical to how a challenge of this kind is decided. It's very likely that the WA measures, in my view, started valid, potentially became overly strict at a particular time when containment had been very successful, but the events in Victoria have meant that it has now become more necessary to close the border, and that issue of shifting validity is one that the High Court has had very little occasion to consider in the past, and raises fascinating issues that I think will be of great interest to constitutional lawyers and scholars should the court actually have occasion to address it in October. But the other issue around timing that I think is tricky when it comes to questions of reasonable necessity or proportionality is that when it comes to dealing with an epidemic or pandemic of this kind, there are basically two broad policy choices. One is a limited set of restrictions that are likely to last for a very long time, unless and until a vaccine is available and widely deployed. So let's call that the medium restriction, but for a long period of time option. And then there's the overwhelming force for a relatively short period of time. So massive lockdown, Category 4 restrictions and or complete bans on travel across state lines. Courts have had very little opportunity to determine questions of proportionality when they're forced to choose between medium restrictions for long periods of time and very, very stringent restrictions for a shorter period of time. And I think there is actually a very real debate about which is more proportionate. Is it worse to have restrictions ongoing but more limited restrictions, or greater restrictions for a more limited period of time? You know, of course, the more limited period of time overwhelming force is a familiar one from a sort of military perspective. It's Colin Powell's overwhelming force doctrine. I personally think it has a lot of appeal if you are aiming at elimination. Again, if you're looking at containment, more medium level restrictions for longer periods of time makes sense. But again, it's a question of time frame in assessing reasonable necessity, and I think it's a very interesting and important issue to grapple with, and one that I think the court will find difficult, and therefore tend to defer to experts, providing the experts articulate their rationale clearly and coherently and in a way that is consistent with the appropriate legislative record and the conduct of the executive in enforcing the relevant restrictions. So I think there is really interesting issues ahead. I do think that it's very likely that the relevant measures, while the pandemic in Victoria is so concerning, will be de facto or formally upheld. As Anne said, the time frame may mean that by October we hope that it's not as live an issue, but while we see the levels of community transmission in Victoria, I think whether it's a trade and commerce argument or an intercourse argument, it is likely that we will see those measures upheld, but no doubt there will be a need to revisit that conclusion as we hope the pandemic comes under greater control in Victoria.
Well, many thanks to Rosalind Dixon and to Anne Twomey, our two professors today, and we'll come back shortly with a question and discussion period. Thanks. Thanks for stimulating papers. Now we come to questions and discussion. Some of our members have sent in questions, but because we have a lot of history tragics who at the Sydney Institute, I'm just going to ask you a couple of historical matters before we move on to the current issues. So, firstly, the Spanish flu really reaches Australia in 1919, so it's really 1919, 1920. State borders, as I understand it, is closed. Were there any legal matters discussed?
Well, to the best of my knowledge, there wasn't a Section 92 challenge. Certainly there were little bits and pieces, if you look in the newspaper, sort of arguments about whether the judges should have been wearing masks in court and criticising them for not wearing masks in court. I think at one stage one of the High Court judges was having difficulty getting from Melbourne into New South Wales to come and do a hearing. So there were some practical difficulties going on, as indeed there are at the moment in relation to court cases. But it is quite interesting that nobody took, as far as I know, nobody took the Section 92 point, at least not all the way to the High Court anyway.
And I think the other thing that's very interesting is we've obviously got regimes in place at the moment which do try very hard to create reasonable exemptions and give people who have a very compelling reason a basis for going across the border. And there are pictures from 1919 and 20, if you go back and look at the archive, of people literally in tent camps
on the border,
stuck on one side of the border. So whatever the measures that were in place then, we've come a long way in 100 years in terms of, when I and others were advocating for closure, we were explicitly saying Albury-Wodonga and people along the border, there should be green zones and there should be exemptions, and no one stuck in a tent on the wrong side of the border. And so we actually have learned some of the lessons of not creating appropriate exemptions from that historical experience.
And briefly, when a lot of us think of the Section 92, we think of the engineers case that, on a totally unrelated matter, that gave Robert Menzies his first entry into the public sphere, when, as I understand it, the High Court overturns the first 2 decades of findings. So briefly, very briefly, just tell us what Menzies was advocating and what happened there.
Well, Menzies was advocating for an approach to the Constitution that was less based on a theory of compact. The people who wrote the Constitution saw it in terms of a political social compact and were interpreting it that way in terms of the states and their relationship. So you had ideas of reserved state powers that aren't literally in the Constitution. And what the court did in the Menzies, in the engineers case, was to move back more to looking at the Constitution as a legal document, interpreting it as a statute, looking at the text, looking at the words of it, looking less at what was in people's heads when they wrote it in terms of some kind of a political settlement. So 1920 was that sort of tipping point from an original High Court made up of people who wrote the Constitution, who knew what it meant because it meant what it said in their heads, to a new lot of people coming in who are reading the Constitution as a legal document. They're reading it as lawyers and they're interpreting it in a much more sort of formalistic way.
And I would also add that there's a live debate about what engineers stands for. There's going to be a really interesting symposium in the Australian Law Journal around the 100th anniversary of the decision. What does it stand for? And Anne herself has written a brilliant piece that looks at this history, which is it's not only about affirming Menzies' kind of argument for it's a legal document, read it on its terms. It also reflected a changing sense of nationhood from a state, Australia is a compact among states and Australia is a nation, and that was forged obviously in World War I and Gallipoli, and an emerging sense of the Australian nation as requiring a stronger Commonwealth, as Commonwealth legislative power expressing that sense of nationhood. And Anne's written about the history of the personalities. It's a wonderful read. I'd highly commend it to people. But it was this shift to an alliance. Menzies got his numbers right on the court between those who really wanted to see the Constitution as a legal document, like a statute effectively, and the nationalists who said, look, we are a compact of states, but we're more than that. We're a nation, and it's time we recognise that. And Justice Windeyer states that beautifully in the payroll tax case, looking back on engineers. So engineers is one of those great decisions, is you can see what you want in it. It's got something for everyone. And even though people have said 100 years on, look, it wasn't written that well, it lives on, and part of the reason it lives on is it's got these multiple strands of nationhood and legalism which have a lot of appeal for different audiences. So in a practical sense, what was the difference if you were trading between the states in 1921 than in 1919? I mean, what
what actually changed?
Not much, other than that the Commonwealth gained greater power to legislate in ways that affected that relationship. So it wasn't so much about Section 92 per se, but about the broader scope of the Commonwealth's power. It took until, the Mason Court essentially for that across state lines relationship to look radically different.
It took until what?
The Mason Court and
Cole and Sir Anthony
Whitfield.
Mason's court. Okay.
Correct. And that decision that both Anne and I referred to in Cole and Whitfield in the late 80s as the sort of sea change. If you're the person wanting to trade across state lines, you were no longer able to say, as Mr. Parnas wants to, I'm a trader, I have rights. Now it's no, we're a nation. The question is, how is the national market affected? But certainly the Commonwealth gained greater power to regulate the relationship by virtue of the engineer's case.
Now, talking about the Commonwealth, as you know, in relation, I think, in relation to the one continuing matter, which is the Palmer case, the Commonwealth, the Attorney General, Christian Porter, indicated that the Commonwealth would enter this case, and at that time, my understanding is that the Morrison government was opposed to a hard lockdown on the borders, or relatively hard lockdown on the borders. So, do we know what's going to happen with the Commonwealth government now that the Morrison government seems to have gone along with the decision, or it may have, I'm not sure, it hasn't been talking much about this. So where do you think the Commonwealth will come in on this?
Well, I think it's quite difficult for the Commonwealth now. Previously it was saying there was no medical evidence to support closing state borders. I think it's now moved a little bit away from that statement, particularly now that it's apparent that it really was a sensible thing to shut the border between New South Wales and Victoria, and probably should have been shut a bit earlier. There has been some criticism of the Commonwealth for intervening at all. I think in such a case it would be inevitable that the Commonwealth would always intervene. It does need to express its views in relation to the interpretation of Section 92. That's an important matter. Key question is what view it puts, and it might well still be able to put a view which suggests that the position at the time the proceedings commenced was one where it was not reasonably necessary for Western Australia to maintain that border being shut, but that when events changed with the Victorian outbreak, that there were sufficiently significant differences in facts that meant that it was appropriate for a border to be shut. So I would expect that the Commonwealth will be taking a nuanced position depending on the basis of the facts at the relevant time.
Or it might even simply amend its positions to express a view on the law but not its application in these circumstances. I think one of the challenges is that the Prime Minister has been reluctant to support very stringent measures in a whole range of contexts, but he is listening and he's often persuaded over time by the Premiers or others in the Cabinet of the need for those measures. And so I think the Commonwealth's position is evolving, and that's likely to be reflected in its litigation position as well as in its broader political position.
So you think it might, it will intervene, right?
I would expect.
And when it does, you think it will say...
I do not think it will hard oppose the WA law. It will either say, in some circumstances we would support the WA law while there's a live outbreak of the kind you see in Victoria, or we take no position on validity, we simply take a position on what the right approach to the law is in general terms. Because as both Anne and I said, there is this general question about what's the right position in relation to the intercourse limb of Section 92, and that's an issue on which the Court will want to hear from the Commonwealth. But the Commonwealth wouldn't need to express a firm view as to how it applies in the particular case.
Yes.
Can I put a controversial view? In a sense, the current responses to COVID-19 have led to a situation where the public sector is essentially putting the private sector under great economic distress. And now, when in your, for example, because whether it's people who are in the public service, in the health departments of the public service, politicians, academics commenting, journalists, some journalists, public broadcaster commenting, A lot of them are going, well, we don't know what the judiciary is going to say yet, but we know what the health departments are saying. In a sense, many of them are going for a pretty hard lockdown, which is having a very deleterious effect on the private sector economy without affecting the public sector economy. Now, when you were talking earlier about what the High Court's looking at, or likely to look at in relation to medical factors and trade factors, no one mentioned economic factors. I mean, is that a consideration that not the federal court, which is looking at facts, but the High Court, if it gets there, will be looking at? I mean, is that a consideration in all this, or does the deleterious economic impact of the closures have a relationship to the medical impact of the closures?
I think Anne alluded to that. Ultimately, Section 92 is about economics. It's about the benefits of a national market, and that was the realignment we saw in Cole and Whitfield. So whether it's explicit or implicit, the court is interested in economic considerations. It wants, basically, all else being equal, free trade across state lines, including in personal services. So the economics is absolutely there as the sort of rationale for the proceedings. On the specifics, I wanted to just respond a little bit to your provocation. Firstly, I think it's unfair to say that the public sector is fully immune. New South Wales, like a lot of state governments, has announced a public sector pay freeze. That's showing solidarity with the private sector. My own university last week announced 500 jobs will be lost, more are likely to come. So the public sector is actually suffering. And the second thing is, I don't think it's the public sector imposing the costs on the private sector. I think it's the virus. And I think that it's really important to be clear that the virus has had a devastating economic impact worldwide and will continue to, unless and until it's fully eliminated or there is a vaccine. And we have to distinguish the fact that in places where this is running rampant, no one wants to go to restaurants, no one wants to go to the movies, people don't feel safe. And I spend a lot of time living in the US, and I talk very frequently to colleagues there. I have been talking to colleagues in Brazil, in Chile, places where the virus is not under control. And the economic devastation is just as significant. And so it's not only government that's causing this. If anything, the evidence from recent studies is it's the virus that 90% plus is causing the economic pain, and that the measures that are designed to eliminate or contain may exacerbate it in the short run, but it's an investment in the long run economic health. If we can get the virus under significant control or eliminated within the community, the economy can rebound. And if we don't, people will continue to self-isolate, save rather than spend, and businesses won't feel confident to hire and expand because they know another lockdown or contraction may be coming. So I totally understand the argument, but I do think it's incorrect to suggest that A, the public sector is fully insulated, because it's not, and B, I think this is the virus, not the government, that's really inflicting the economic harm.
But then the virus is also having a medical impact with people not going to their doctors, people not getting their checks, people not getting elective surgery. So
correct.
The virus is having a medical impact as well as an economic impact.
Correct. And a social impact. People's mental health is suffering.
And indeed, there are also, there are so many impacts. One of the more remarkable ones was, if you look at things like road deaths, for example, there'd be a lot of people wandering around alive today who would otherwise have been dead because they weren't travelling in a car, and therefore they weren't in that car accident that would have killed them because they weren't travelling. There's ups and downs and everything, and there are horrible questions about how you work out how that plays out in the long term. There will be people who are alive today who otherwise wouldn't be, and vice versa.
Now, you two are both lawyers, but you also got a good sense of history. So take us back to 1919, 1920, when, as I understand it, official figure I think is in Australia is 12,000 dead. The likely figure is 15,000 dead in a population of 5 million. So that would be the equivalent today of 75,000 dead. At the moment we're about at 130. The borders were closed, but a lot of other activity continued. There were full rounds of rugby league and Australian rules football played, and the economic impact doesn't seem to have been as great in 1920, since we moved into 1920-21 recovering from the war, as it is at the moment. So have you looked at the reactions? You were making the point earlier that no one contemplated going to the High Court about border closures, but I mean, is there a different kind of concept around? I think in the Spanish flu worldwide, the estimated death toll is somewhere between 40 and 50 million. At the moment, we're dealing with about, I think, 600,000.
I think, Jared, one of the things that's changed is our notions of life expectancy, and people had a sense then that there were many very severe, infectious outbreaks that could kill them, and we've come a long way in how we can treat and cure, and our expectations around protection of health are higher in a good way. I also think the other thing that is important to acknowledge is, as Anne said, we live in an era in which the economy can adapt and continue in many sectors through technology, and that no one had the option in 1920 to do business via Zoom or Skype or via electronic platforms. And one of the things that is different is that the choice for cafes and for licensed clubs is very wrenching. But for huge sectors of the economy, the choice is not between no business and business as usual. It's a choice between adaptation and the old ways, and some of that adaptation will be for the good. And so I think implicit in your question is that we're overreacting, and I think we've changed our views about treatment and public health because of the possibilities of modern medicine, and B, we have more opportunity to protect the economy and adapt than we did then. I also think that it's really, really important to note that the levels that we're talking about at the moment are in part the product of governments taking decisive action. And many of the people who survive severe cases of COVID, it looks like they're going to have lifelong or at least medium to long-term health effects, which is severe and should be counted in that toll along with deaths. So I think the fact that we're not seeing those huge numbers is in part the product of the fact that many governments have taken decisive action. And we can't simply look at the outputs of those measures and say, see, it's not that bad. We need to factor in that that's the product of policy.
Extending beyond state borders, I think, Anne, you were talking about intrastate matters. What is the legal status of state governments who, and it would be different from state to state, I guess, who want to lock down certain suburbs, certain local government areas, certain towns? Are there any inhibitions on that at the state jurisdiction level? Or can state governments do what they like?
It's much easier for a state to do that because states have plenary legislative power, so they have all power to do whatever they like unless the Commonwealth Constitution has taken it away from them. So unless it was inconsistent with the Commonwealth law, probably the state can do that. And of course the other thing is you need to make sure you've got the legislation in place allowing you to do that, and if your Parliament's not sitting, it can be quite difficult to do that. But subject to that, I think, yes, they can impose lockdowns. There are also, of course, constitutional issues about detaining people, against their will, and the need for that to be done in a judicial way rather than by a court, rather than by government. But there has always been a recognised exception in relation to quarantine of communicable diseases in relation to that. So I think that's not going to be an impediment either. So yes, states can do it. The question then is how practicable is it to do? And as I said, it is easier to do this sort of thing along borders where you know where the border is and there's defined difference. It's much harder to put borders around postcodes and suburbs and local government areas.
I've got about 7 minutes left and a couple of extra questions from our members, so I'll just run through them. Question: can the federal government pass a law, if it wanted to overturn state border closures? Could it do that?
Possibly. So first of all, the Commonwealth would need a head of power. You could argue that it's quarantine power might be enough. So it could, for example, say, the only laws in relation to quarantining people that can apply, that this Commonwealth law concerning quarantine is comprehensive. It is intended to cover all issues about quarantine in Australia and exclude all other state laws. Okay, you could do that, but then the question arises as to whether that breaches what's known as the Melbourne Corporation Principle, and that is a principle that says that the Commonwealth cannot restrict state constitutional powers in such a manner as to curtail the capacity of the state to function as a government. And so then there'd be a real question as to whether a state losing control over both its borders and the ability to protect its people from public health would be sufficient to trigger that Melbourne Corporation principle. So if I were the Commonwealth, I'd probably stay out of trying to do that, because you just end up in a whacking great fight in the High Court, and probably best to deal with these things cooperatively rather than trying to come in with a big stick. So the Commonwealth could try it, but there would be doubt as to whether or not it would be successful.
And as you know, it'd be unlikely to get through the Senate, I expect.
Yes, and I think Anne's exactly right in that they could also try relying on the trade and commerce power, which hasn't been fully explored since the 70s really as a source of power. But I think their ability to do it would depend on how sensible they were being about, if they had a comprehensive national quarantine framework, you could probably say that it wasn't taking states' capacity away, it was working based on what they've done. But if it was an attempt to simply clear the field, given the issues you talk about in Melbourne Corporation, I agree they'd be ruled out.
A couple of issues raised about fruit and plants bans that have existed between the states for a long time. So the question is, why is that, just coming from one of our members, why is that any different from what's proposed at the moment in relation to people?
So this is about the taking your fruit across the state border.
Similar, except that an apple is not capable of movement by themselves, and so it comes under the trade and commerce limb, which is a little bit less protective than the personal movement limb potentially. And then you have to say, well, it's a discriminatory measure. It engages Section 92, and the question is it a reasonably necessary measure for a legitimate purpose? Clearly preventing the transmission of fruit flies or other plum and animal diseases is a legitimate purpose. Is it a reasonably necessary measure? And given that there are exemptions for commercial traffic, it's only kind of personal taking across that is prohibited. Probably it's proportionate and legitimate. So I think that it's a good question. It's not that different, except that it's engaging a somewhat different limb of the guarantee.
And those laws have been in existence for an awful long time, and are effective. As a child, we lived near the border between Victoria and New South Wales, and whenever we got towards the border, it was quick, eat all the apples before we get to the border. So I have lots of experience of this.
So finally, a Sydney barrister, no less, has put in a question which really takes us back to where we started. Section 92, as you've both pointed out, talks about the trade and commerce, whatever, being absolutely free. So the question is, what's the point of the word absolutely in Section 92 if it is to be read down to something much more qualified? I guess it takes us back to 1920, doesn't it?
Oh, it takes us back to before that.
Yeah,
it takes us back to, somebody said when it was put in, I've forgotten now who, but it was a little piece of layman's language. Let's get away from all this lawyer talk. Let's put something plain and clear in there. And you just thought it was a catastrophe. This has been the hardest to interpret provision in the Constitution we've ever had. It's had more difficult interpretations than any other, more court cases because of that. And the reason is that there's inconsistency in the Constitution itself, because Section 51(1) of the Constitution gives to the Commonwealth Parliament power to make laws that regulate trade and commerce between the states. And then you've got another provision, 92, that says trade and commerce between the states shall be absolutely free. Well, you've got to rationalise those two. They have to be able to sit together. So if you've got a power to regulate trade and commerce between the states, then clearly it can't be absolutely free. So absolutely free must mean something else rather than absolutely free. So yeah, it was a stupid term to put in the Constitution to begin with. I mean, we often praise our framers of the Constitution for doing a darn good job, but I don't think that bit fell within that category.
I think we now see it as rhetorical flourish, basically, and it was a mistaken rhetorical flourish. Barristers would understand the attractions of the rhetorical flourish, and in this case, it was a mistaken one. But it's why I drew the analogy to the First Amendment. It's very powerful language to say, Congress shall make no law abridging the freedom of speech, and yet that's a rhetorical flourish. It can't logically or structurally be understood as no law. It has to mean no law of a certain kind, and it's the same for Section 92. Absolutely free just means reasonably free, and one sounds better than the other, but one's more logical and understandable. And clearly, we've grappled with that, but since the late 1980s, we've all understood that the word absolute actually means reasonable. And when you hop on a yacht and you want to write an inspiring constitution, sometimes you use flourishes that don't stand the test of time.
It's a great place to end. Thanks for great papers and a very stimulating discussion. Thank you, Ros. Thank you, Anne.
Thank you, Jerry.